It's stating that she is minimizing guilt. And in the PSI report, she seems to argue that this is.
Good morning, Judge.
Good morning. All right, the court is calling 2025 CR 015787 State versus Alicia Jimenez. Can I have parties announced?
State of Texas.
Sharon Thorne for the defendant, Your Honor.
Alicia Jimenez. All right, thank you. All right, Ms. Jimenez, you entered a plea to count one. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine. State is silent on your application for deferred adjudication. They're taking in consideration 2025 CR 015767-02. There's to be no contact with the complainant, and there's an affirmative finding of deadly weapon. Did both parties have a chance to review the? Yes, that's yes. Yeah, no, that's okay, Rick.
Yeah.
All right. Yes.
Right.
All right. Have both
Yes.
parties had a chance to review the PSI report?
No objection. I've reviewed it with my client. No.
All right. The state is silent. Thank you. All right. Any other witnesses?
Yes, Your Honor. I would like to call my client at this time.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
So when questioning your client, if you can clear up for me, because in the PSI report, it's stating that she is minimizing guilt. And in the PSI report, she seems to argue that this is self-defense and that she has no idea what's going on. So if she wants a jury trial, then, we're here for that.
Ma'am.
All right.
Proceed.
Yes.
State your name, please. Alicia Malik Jimenez. And you understand why we're here today?
Yes.
And you pled no contest to this offense of aggravated assault, correct?
Yes.
Okay. Now you understand what the judge was asking. There's some things on the PSI that you and I discussed. And you tell the judge now today, do you accept responsibility for what happened?
Yes, I do, Your Honor.
You understand the charges against you?
Yes, I do.
Are you asking for a jury trial?
No, I'm not.
Are you making excuses for what happened?
No, I'm not.
And you understand that there was a complaining witness, a victim in this case.
Yes, I do.
And that's why we're here.
Yes.
And you're asking this court to grant you deferred adjudication, and you're not making excuses for what happened.
No, I'm not.
With that, Your Honor, I'd like to continue with questions.
All right. So she's not going to be alleging self-defense.
No, Your Honor.
Okay. All right. You can proceed.
Thank you.
Thank you.
Okay. Now, you and I have gone over this PSI, and we've gone over the facts of the case, we've gone over your criminal history, correct?
Yes.
And you acknowledge and own your history. You know what you've done, and things that, in fact, you've been to prison.
Yes, I have.
Knowing that, you were still asking this court to grant you deferred adjudication and give you a second chance.
Yes, ma'am.
Your mother's here, correct?
Yes.
And your daughter's here. Your mother, she went to this, correct?
Correct.
And in fact, when you were 14 is when your mother went to DC and you ended up in foster care.
Correct.
Would you agree that that kind of started the spiral of problems that you have?
Yes, that's true. Correct.
Okay. But again, we're not here to make excuses. Right? Okay. Now, since you've been in custody here in Bexar County.
Notice what the defense attorney is doing here. She's presenting the defendant's difficult upbringing to explain the path that led here, but immediately reminds the court they're not offering it as an excuse. That's a delicate balance in sentencing. Judges often want context, but they also want accountability. And striking that balance can make all the difference.
Is it true that you've been involved in Bible classes?
Yes.
And would you agree that you've kind of awakened your spiritual side?
Very much so.
In fact, that letter from one of your fellow inmates, they recognize that you are doing much better and you're kind of a leader at the jail.
Yes.
And you are trying to be better and trying to have a better life for your children, for your grandchildren, and your mother.
Yes.
You wrote a letter to the judge.
Sure did.
Would you like to read that letter?
Yes. Is
With
that
your-
okay with you?
With your permission, Your Honor.
Well, it's fine with me. However, the state will need to review it. And then once they review it, if they're fine with that,
Okay.
then I
Thank you.
will listen, of course.
And while they're reading it, could I ask for some more questions?
Yes.
Okay. Now,
We'll just
so, and I know you told probation and you tell the judge that you have some serious health problems. High blood pressure,
high blood pressure and
severe asthma, depression, you've been diagnosed with depression, anxiety,
anxiety.
bipolar 1 and 2,
Yes.
PTSD,
Yes.
and ADHD.
Yes.
Do you take medicines for those diagnoses?
Yes, I do. I was enrolled in Animal Premier. That's my psychiatrist, and I also take medications here.
Okay. So prior to your incarceration, you were seeing a counselor or therapist,
Yes.
and if you were to be continued or granted deferred adjudication, you would continue with that, and they would monitor your medications,
Yes.
and they would make sure that you're seeing. Is it a psychiatrist you see?
Psychiatrist, counselor,
And a
at the same
counselor.
place.
Okay.
I was gonna leave that out.
Oh,
I
no,
could
Just
go
have
ahead
a
and I was gonna
moment
leave
with
it
my
out.
client.
Sure.
Yeah, I was gonna leave it out. I know it's reactions. Yes, I was gonna leave that out.
Okay.
I'm nervous. I'm sorry.
It's okay.
I apologize.
Okay.
It's been a long 8 months.
Okay.
Can I read it to you?
Yeah.
Sure.
I can basically just tell you that I wanted to apologize to my victims, apologize to you, Judge Boyd, to my attorney, to the district attorney, and especially my family, for putting them to the pain and the cause. With that being said, that it doesn't define, the reports do not define who I am. I'm a very loving mother. I'm a very loving grandmother. And I care for my mother who is here, who is ill. I was known to have sufficient, I have been known to have, be sufficient and dependable. I'm a caregiver, like I said, to my mom and a provider to my grandbabies. I've also surrendered myself to the Lord Jesus Christ, who is capable of forgiving, healing, and changing me for the better. I come before you to ask if you would consider giving me another opportunity to a fresh start, to a new life, and to a better career to educate myself. I want to be a service to my fellow church. I also want to help change lives. I was thinking about trying to get into prison ministries to help the broken and to minister them. And with that being said, I just wanted to be able to share my accomplishments with my family. And I want you to know that I would make better choices. And thank you for your time.
All right. Thank you so much. All right. Any other questions?
No, Your Honor, I believe she really said it all. We were just asking, on behalf of her and her family, for you to consider deferred adjudication. I know it's kind of thinking outside the box with her record, but I believe that she's come to hopefully a change in her life, and I think you would have a good choice in granting her deferred. And as I stated in my sentencing memo, if you were to give her deferred, you would still have a big, huge hammer over her head. And if she messes up, I explained this to her. She's looking at 20 years, and you would have that over her. But I think
The defense has now made its strongest pitch: give her deferred adjudication instead of prison, with the threat of a much harsher sentence hanging over her if she violates probation. It's essentially asking the judge to bet on rehabilitation over incarceration. Would you take that chance if you were the judge? Let us know below.
and I hope that you would consider deferred adjudication and that place her on 10 years deferred adjudication with all the bells and whistles that are needed. And I do believe that she'll be successful.
All right. So, Ms. Jimenez, this is what I can tell you. It would be nice if I had something in front of me that could tell me how people will behave or whether they will be successful on probation or not, whether or not if I place them on probation, they're going to commit new offenses. But I don't have that, right? So I just have to look at evidence before me and consider things as a whole, right? And so I don't think you would be a good candidate. And this is why. I don't think you'll be a good candidate, but I can tell you right now, I'm not going to sentence you to do 12 years. This is why I don't think you'll be a good candidate. You've been on probation before for assault, family violence. And I realized that was a long time ago.
Here comes the explanation everyone in the courtroom has been waiting for. Instead of simply announcing the sentence, the judge carefully walks through the defendant's criminal history and prior opportunities on probation. Judges often do this to show that their decision isn't based on emotion. It's based on patterns, prior outcomes, and the evidence before the court.
In 2001, but it was terminated unset. All right, and your attorney knows what terminated unset means. Now, you have a lot of cases that have been dismissed. I'm not even considering those because they were dismissed. I don't know what they were dismissed for. You have a criminal mischief from 2009. You did time. They gave you a judgment satisfied. Then you had another theft case from 2018. Judgment satisfied. A resisting transportation. That's the same time frame as the theft case, judgment satisfied. Then you had the abandoning of a child case. And with that, there was a motion to revoke file, and then they terminated your probation unsatisfactorily. Then the other cases where they say, oh, we dismissed it for a missing witness, I'm not considering that at all because I don't have any facts for that. But then you had another aggravated assault with a deadly weapon. And for that one, you received 4 years in the prison. And that's from 2020. And now you're here on another aggravated assault with a deadly weapon. So that's why I don't think you're appropriate for deferred adjudication. So the court is not going to grant your application for deferred adjudication. What the court will do, the court is going to find you guilty. There's a $1,500 fine. Time and money to run concurrent. Take in consideration 2025 CR 015767-02. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Ernesto Coronado or Luis Luvano. There's to be no unsupervised contact with minors, and the court will sentence you to 7 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it, and did you sign it? Yes, sir. All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you'll need to speak to an attorney. And what I will do, if I didn't say it, I'll put in there the therapeutic community for mental health. And I'll also let them know therapeutic community just based upon the stipulations for any type of drug or alcohol issues. Thank you. All right.
In the end, the judge denied deferred adjudication but also chose 7 years instead of the 12-year maximum allowed under the plea agreement. She also recommended mental health and substance abuse treatment while incarcerated, signaling that punishment and rehabilitation can exist together. Do you think this sentence was fair, too harsh, or too lenient? Share your thoughts in the comments.
Thank you. Good luck to you, okay?
Thank you, baby.